Hi, Assalamualaikum and good day everyone. My name is Alia Mahira and today I will be presenting our case review. Our group consists of 6 members. I will start by giving a brief overview of the case before moving into the main issues, court decision and more details by my fellow friends. The case we are reviewing is SMFL Hire Purchase Sdn Bhd against Linsun Trans Energy Sdn Bhd and others. Have you ever wondered what happens when a company stops paying for vehicles purchased under a hire purchase agreement? Well, that's exactly what happened in the case of SMFL Hire Purchase Sdn Bhd against Linsun Trans Energy Sdn Bhd and others. In this case, SMFL Hire Purchase provided financing to Linsun Trans Energy for several standard prime movers and semi-trailers through non-purchase agreement. To secure the transaction, 3 guarantors also agreed to be responsible if the company failed to make a payment. Initially, everything went according to the plan. However, the transport company later failed to pay the monthly installment required under the agreement. As a result, SMFL repossessed the vehicle, sold them, and then demanded payment of the remaining outstanding balance. This led to several important legal questions. First, did the Hire Purchase Act 1967 apply to these agreements? Second, could the financier repossess the vehicles without giving prior notice? Third, were the vehicles sold at a fair price? And finally, was it valid to include both a prime mover and a trailer in the same hire purchase agreement?
The most important legal principles established in the case of SMFL Hire Purchase Sdn Bhd against Linsun Trans Energy Sdn Bhd, it relates to the scope of the Hire Purchase Act 1967, freedom of contract and the validity of commercial hire purchase agreements. First, the court clarified that the Hire Purchase Act only applies to goods listed in the first schedule of the Act. In this case, the trailers exceeded the statutory weight limit of 2,550 kilograms and were therefore classified as non-scheduled goods. Second, the case reinforces the principle of freedom of contract. The hire purchase agreement expressly allowed the financier to terminate the agreements and repossesses the vehicles upon default without giving prior notice. The court held that the parties who voluntarily enter into contract are generally bound by the terms. Therefore, the plaintiff was entitled to repossess the goods when the first defendant failed to make the required installment payments. Third, the court emphasized the duty of financier to obtain the best price reasonably and obtainable when selling repossessed assets. The plaintiff successfully demonstrated that the vehicles were sold through public auctions after proper advertisement were published. Since the defendants failed to prove any undervaluation, the court found that the plaintiff had fulfilled its obligation. And finally, the court confirmed that a single hire purchase agreement may cover more than one item of goods when those items are complementary. The prime movers and traders were intended to function together in the transportation business, making the agreements commercially practical and legally valid.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Azim bin Muhammad Saidi and my ID number was 083729. So in this section, explain when the Hire Purchase Act 1967 applies and when it does not. First, the Section 1, Clause 2 limits the Act scope and the Act applies only on the goods listed in the first schedule. If the goods are not scheduled goods, the transaction is governed by a common law contract principle and not by the Hire Purchase Act. Second, the first schedules impose a weight limit for a goods vehicle. A goods vehicle is covered only if its maximum permissible laden weight does not exceed 2,540 kilograms. If the weight exceeds the limit, the Act does not apply. Third, vehicle classification matters. A motor vehicle must be capable of self-propulsion. A trailer cannot propel itself, so it is treated as a good vehicle. Because the trailer in this scenario exceeds 2,540 kg limit, it fell outside the Act. Fourth, the Section 4D generally requires separate hire purchase agreement for each item of goods and high compliance can render the agreement void. However, this requirement applies only where the Act itself applies. Finally, Section 4D Clause 4 creates an exception for a complementary good sold as a set. A prime mover and a trailer are complementary items. Therefore, they may be treated as a single item, making one combined agreement legally valid. So, in short, check the first schedule, check the 2,540 kilograms limit, and whether the items are complementary goods before applying the Section 4D's separate agreement rules. Now, I will pass to the next presenter.
Next, I'm going to explain the rights and obligations of the owner or financier in the hire purchase agreement. First, let us look at the rights. The owner or financier has a right to keep legal ownership of the goods until the hirer finishes paying all the installments. They also have the right to receive the installment payments according to the agreement. If the hirer fails to make payment or breaches the agreement, the owner has the right to terminate the contract. They may also repossess the goods, but this must be done according to the terms of the contract and the law. After repossessing the goods, the owner can sell them to recover the outstanding amount. If the money from the sale is still not enough to cover the debt, they may claim the remaining balance from the hirer or any guarantors. They can also charge late payment interest, but only if it is stated in the agreement. Now, moving on to the obligations. The owner must provide a written hire purchase agreement that is signed by all parties and give a copy of the agreement to the hirer within the required time. If repossession takes place, it must be carried out lawfully and follow the legal procedures. The owner must also sell the repossessed goods at the best reasonably obtainable price, act in a good faith, and be transparent throughout the process, and properly account for the sale proceeds after the goods are sold. So basically, while the owner has several legal rights to protect their financial interests, they also have important responsibilities to ensure the hirer is treated fairly and according to the law.
Hi everyone, today I will be presenting on the rights and obligations of the parties under the hire purchase agreement, focusing on their hirer, who is the buyer, or the use of the goods. Firstly, the hirer has the rights to possess and use the goods immediately after signing the hire purchase agreement. Secondly, the hirer has the rights to receive a copy of the hire purchase agreement within the prescribed time. The hirer also has the rights to be informed clearly all the terms and conditions, including the installment amount, duration of the payment, interest charges, and the penalties. In addition, the hirer has the rights to terminate the agreement early by returning the goods and settling any outstanding balance. The hirer also has the rights to redeem the goods at any time before the final installment payment by paying the remaining balance due. Furthermore, the hirer is entitled to protection under the Hire Purchase Act 1967, which applies to scheduled goods. Lastly, if the goods are repossessed, the hirer has the rights to demand that the goods be sold at the time of best reasonable prices. Next, let's look at the obligations of the hirer. The hirer must pay all installment on time according to the agreement. The hirer must also take reasonable care of the goods while they are in their possession. In addition, the hirer must not sell, transfer, or dispose the goods without the owner's consent, because the ownership remains within the owner until all the payment are completed. If the agreement is terminated or the hirer defaults on payment, the hirer must return the goods. Where repossession occurs and the sale of the goods is insufficient to cover the debt, the hirer must pay all the outstanding balance. The hirer is also required to comply with all contractual terms and conditions stated in the agreement. Finally, where all the guarantors, the hirer may be involved in liabilities arising from the guarantor's obligations due to joint and several liabilities. In conclusion, a hire purchase agreement provides important rights to protect the hirer, but it also imposes several obligations. Therefore, the hirer must understand both the rights and the responsibilities to avoid the legal disputes and ensure the agreements run smoothly.
Now moving on to the practical legal awareness and commercial initiative relating to hire purchase transaction. So the first point is importance of understanding contractual rights and obligations. So it is very important for both parties to carefully understand the terms in a hire purchase agreement before entering into the transaction. This is because clauses relating to default, repossession, and outstanding liabilities can significantly affect the rights and obligations of both hires and financiers. In many cases, consumers tend to focus only on the monthly installment amount and do not fully understand the legal consequences written in the agreement. As a result, disputes often arise when they later realize obligations that they were not aware of at the time of signing. Therefore, a clear understanding of the contract is very important. It helps parties know their responsibility from the beginning and reduce misunderstanding that may lead to legal action in the future. Next, transparency and compliance are essential in hire purchase transaction. Hirers must comply with their payment obligation according to the agreed schedule to avoid repossession and additional financial liabilities. At the same time, financiers should maintain proper records and ensure clear communication, especially regarding repossession procedure and the disposal of repossessed goods. Even though some notification may not always be legally required, providing clear and timely information helps improve transparency and reduce misunderstanding between parties. In addition, proper communication also helps create accountability and ensure both parties are aware of updates regarding the agreement. Overall, when both parties act transparently and comply with their obligation, it promotes trust, smoother commercial relationship, and reduces the risk of disputes.